In the previous one, the HSC funding.
It is restored by that LJC.
My Lord will permit me to be dates. I have prepared a short synopsis for your Lordship's consideration, just to assist you, Lord. Lord, the charge.
You have brought the original report.
Huh?
I have brought the original report.
Lord, the charge memo, if Lordship will have, is at Annexure 3 at page 20. Just a small write-up, Lord, I have prepared for your Lordship's consideration.
Wait for a minute.
Petitioner has challenged Annexure 9. Lord, petitioner has challenged Annexure 9, which is the order of punishment, and the appellate order at Annexure 12.
9.
9, my Lord, at page 36.
Removal from service.
Removal from service, my Lord. And the appellate order at Annexure 12. That is 4/10/2010. Earlier, my Lord, the petitioner had come before this honorable court.
Now, where are the rules in respect of
My Lord. My Lord, the Shastri Award and a bipartite settlement, my Lord. I have done a photocopy of the relevant extract of the Shastri Award and the bipartite settlement.
How is it relevant, this Shastri Award?
My Lord, this is the rule which is applicable to the petitioner and
In the Shastri Award, there is a provision for the initiation of inquiry.
521, my Lord. Procedure, section 3. Procedure for taking disciplinary action.
Huh.
521 says, my Lord, a person against whom disciplinary action is proposed or likely to be taken should, in the first instance, be informed of the particulars of the charge against him. He should have a proper opportunity to give his explanation as to such particulars. Final order should be passed after due consideration of all the relevant facts and circumstances. With this object in view, we give the following directions. Then, my Lord, the directions are there. Clause 4 explains what is gross misconduct. Then clause 5 specifies the punishment for gross misconduct. 6 defines the minor misconduct. And 7 defines the punishment for minor misconduct.
Which is relevant?
My Lord.
Removal, major penalty.
Major penalty. Although show cause is under clause 7, but the punishment is under clause 5.
Clause 7.
My Lord.
7 is what?
That is the punishment for minor misconduct. The show cause was with respect to minor misconduct, but the punishment which has been awarded is under clause 5, my Lord. Although, my Lord, they say that an inquiry has been held.
The basis to say that charge memo was issued under this clause 7?
But that is stated in the charge memo itself. They say it in the charge memo. And they refer to the bipartite settlement also. And the clause which they refer, that also is for minor misconduct.
Then we will remand the matter.
But that is one aspect, my lord. But what I was submitting, my lord, this is a case where neither any list of documents was given nor witnesses were
Your
examined.
attention of the inquiry was initiated under para 7 and penalty has been imposed with reference to para-
One of my contention is that the rules requires that a decision has to be taken for initiation of an inquiry, and that has to be communicated to the delinquent. Now yes, my lord, a specific decision, the sub clause 9 says of the Shastri Award, my lord, when it is decided to take any disciplinary action.
It is not readable.
Sorry, my lord, may I pass on the book, my lord? May I pass on the book, my lord? Sub clause 9, right hand page top, my lord. Now here, if your lordship will see annexure 3, my lord, what does it say? It says, show cause why a proceeding be not initiated against you. It does not talk about a decision to initiate a proceeding. It says that show cause why a proceeding be not
Have
initiated.
you challenged the initiation of inquiry?
But I participated.
Then how can you take such contention?
Since it came on analysis of the rule,
You
and
have surrender your right before the disciplinary authority.
that is what I also thought, my lord. I had advised my client of this. But even in the inquiry report, your lordship will see they say that no witnesses were produced. Certain documents were produced, copies were never supplied to me, and no witnesses. That is the inquiry report, my lord. It says no witnesses were produced, and yet, my lord, despite the fact that I had produced witnesses in support of my defense, my lord, those witnesses were completely ignored, and merely on his conjectures, my lord, the findings were recorded that charge 1 and 2 are fully proved and charge number 3 is partially proved. These aspects were highlighted even before the appellate authority, my lord.
Number?
Charge number 1 and 2 were proved, and charge number 3 was partially proved.
3 and 4 partly proved.
1 and 2, my lord. 1 and 2 fully proved and charge 3 partly proved.
Among the three
Only
charges,
3 charges. Only 3 charges.
in support of charge number 1 and 2, which documents they are relying on?
With the charge sheet, they gave me nothing, my lord.
No,
What
sir,
do
in the inquiry,
in the inquiry, my lord.
which documents they are relying on?
Yes, my lord. That is mentioned in the inquiry report, my lord. For charge number 1, my lord, they referred to exhibit 1 and 2. And for charge number 2, my lord, they referred to exhibit 3, 4, 10, 11, 19 and 20.
3, 4,
3, 4, 10, 11, 19 and 20. These were the statements made by certain people. One of them was the complainant, who was never produced for cross-examination. None of these persons.
charge number 3 was partly proved
Yes, ma'am.
by which document?
No, he doesn't talk about any document. He says, I feel. Although he notices.
What is the charge number 3?
Yes, ma'am. Charge number 3 is he has been involved in using his influence and managing his complaints, as also revealed from another complaint from the pensioner Srimati so-and-so, SB number so-and-so, and thus interrupting the investigation process in the bank. Now the person who has been named over here, she came before the inquiry on my behalf and she deposed that I had not filed any complaint. even with respect to charge number 1, my lord, the person whose name was disclosed as having complained against me, he had withdrawn the complaint even prior to initiation of the proceeding, my lord. And then subsequently he died, my lord. And thereafter the proceeding was initiated. Then his wife and his son, they came before the inquiry officer and they said that no, he had not made any complaint against this petitioner, my lord. And there was no demand by this petitioner with respect to the money which has been sent.
In terms of Shastri award, where is the requirement of production of witnesses and document?
My lord, the rule says that if
Show us from the Shastri award.
may I have the book, my lord? Lord, probably sub rule 10, my lord, A.
Is anything else?
My lord. My lord, these, then the second show cause notice, it is against,
Can show cause?
second show cause notice was issued after the inquiry report was submitted. The disciplinary authority, even before giving me an opportunity to prove my innocence before him, my lord, had already held me guilty and had proposed the punishment. So the second show cause notice was against the proposed punishment of dismissal. And thereafter,
What is wrong in it?
my lord, the requirement is that before he makes up his mind of my guilt, I should be granted an opportunity, my lord.
You have been provided inquiry officer's report. You have been provided or
My
not?
lord. But the other documents, my lord, which were required to be given to me.
Correct. Have you demanded?
Yes, my lord.
Where is that demand?
Yes. That is annexure 6, my lord. Page 31. By me on so and so, that without providing me the copy of inquiry proceedings, presenting officer's brief, and without giving me the opportunity to submit my defense brief, tentative
Oh,
punishment.
page 31.
Page 31, my lord. A
Okay.
type copy is also available, my lord, on the next page, my lord. Type copy is available.
Read. I surprised to see your.
See your memo number so and so, dated 27/10/2004, 2009. That is annexure 5. That is the second show cause notice of the disciplinary authority, which received by me on 29/10/2009. That without providing me the copy of inquiry proceedings, presenting officer's brief, and without giving me the opportunity to submit my defense brief, tentative punishment advised to me.
This has been ignored by the disciplinary authority.
My lord, yes, my lord.
It has not stated.
No. Rather, it says that we have given you the inquiry report, that is sufficient. We don't need to give you anything else. And again, I reiterate that demand. But thereafter, my lord, the final order is passed. And the final order has been passed saying that orally I have submitted denied the charges. That is, final order is at page 36.
You have not submitted your explanation to the charge memo? Inquiry report?
No, my lord, I couldn't.
You have not filed.
I couldn't file, my lord, because the records which I had demanded and which they were required to give me, my lord, was not given to me. Then these infirmities was highlighted before the appellate authority also, my lord. But the appellate authority also in one line says that since you have not produced anything new, therefore I am rejecting your appeal. That order, your lordship, will find annexure 12 is at page 45, my lord. I find that no additional points of substance which could mitigate your lapse have been mentioned in the appeal. I therefore see no reason to interfere. That is his order.
Under Shastri Award, where is the appeal consideration provision?
My lord,
Again, you want book.
I'm so sorry, my lord, I should have. My lord, it is not given here.
Then how appeal is maintainable?
I have not examined that aspect over here with reference to the Shastri Award, my lord.
Lordship, may I present?
What is that?
Lordship's decision that he has not availed the alternative remedy.
Huh?
Lordship's decision that he has not availed the alternative remedy.
No, he has filed appeal, no?
Lordship, he is a workman and there is provision for.
Which is the appeal provision? Which is the appeal provision? Huh?
There is a Lordship's decision that he should go to the industrial tribunal.
Which tribunal?
Industrial tribunal. He is a workman. He is not an officer.
This is the preliminary issue. All right. On other points?
Lordship will see, he is saying that we have not given the inquiry report. If the Lord, we have given a reply to his letter, Lordship, page 32.
No, you just answer. Charge number 1 and 2 has been proved with reference to number of documents. Author of those documents have been examined, have been cited as a witness. Where are the material?
The documents have been, Lordship, those have been exhibited.
No, author of the document is required to be examined. You are not cited the witnesses.
Lordship, those are the circulars of the bank.
So what? So bank manager, who is the custodian of those circular, he is required to be examined and cross-examined.
Lordship, he never demanded the examination.
Why you should demand? You are relying on those documents. That's all.
Lordship, I will present page 32 of his counter affidavit. We have supplied the inquiry report to him,
That is not disputed by him.
and we have given him
Before,
personal hearing, Lordships.
huh?
We have given him personal hearing opportunity or
Why
personal.
the demanded documents have not been supplied to him?
Lordship, after the inquiry has been completed, through this letter he is demanding
No,
the.
for effective submission of explanation on the on the inquiring officer's report, he may require the proceedings of the drawn by the inquiring authority.
He has been given the opportunity of personal hearing, lordships. He never appeared.
They are asking you one thing, you are saying something.
Now he has presented the defense brief, lordship. He says that he has not presented. The inquiry report has been
On the
supplied.
other hand, he has cited some lady in support of charge number 3.
Now, lordship, his case is that the person who had complained against him has not been examined. Now, that person, lordship, he died. He could not have been examined. Now, his son and his wife
He died on what date?
died, lordship.
Whether presenting officer has stated anything
Yes.
before the inquiring authority stating that complainant so and so has died during. Where is that?
Lord, he died
Yes,
on
Lordship.
14/10/2008.
Lordship, page 29.
10/2008.
What is his name? 2010.
8.
8. Page 29, lordship.
Ram Paras Bhagat.
So before framing charge only he has died.
Now, if your lordship will see page 29, it has been considered that he has
And-
died, and as per the death certificate,
What is his name?
Ram
His
Paras
name was-
Bhagat.
Ram?
Paras Bhagat. Paras, Paras.
His name is Paras.
Ram Paras Bhagat.
Now, lordship, he died, therefore he could not have been examined. Now his wife and son came and said that he was not keeping well, and therefore that complaint was doesn't keep any meaning. So the inquiry officer has considered that since,
No, wife and children have adduced evidence on behalf of the petitioner.
but they have
Why
not
not?
brought the lordship any medical.
Their evidence cannot be accepted.
Lordship, they.
But before his death,
Was he suffering from mental illness? Huh? Where is the document, medical? Was he admitted as an inpatient?
that is what the inquiry officer says, that since the wife and the son could not produce those documents, therefore their contention can't be proved.
Inquiring officer decision is correct. Continue next week. Read this matter heard for some time. Read this matter next week.